Um, Failed to comply with, I'm going to guess, this is a case 24 CR 341. I'm going to guess this is a probation matter. You have a right to an attorney. You have a right to have an attorney appointed. It's probably been 30 days since sentencing. So that it looks like you had an appointed attorney. Did you have Greg Schwartz as your attorney?
Yes, sir.
So he's not representing you right now. You'd have to fill out paperwork for court-appointed attorney. Are you looking for a court-appointed attorney?
Yeah, I thought I already filled out my paperwork.
You might have. I haven't seen it. So, and you might have actually for the first appearance, and we can go over that. Has the state already put in its motion to revoke?
All right, this one here is Evan's fault. It's slow to start. It's not a very long clip. It starts slow, but trust me, it's worth it.
Muted. You're muted.
That, Your Honor, I'm not aware of. This is Mr. Cunningham's case, so I wasn't sure. I do not know.
I'll tell you what, I'll put on the document that you must put in your motion to revoke by the 4th of February.
Okay.
It looks like January 21st it was filed.
Okay. I will not put that in then. It's going to be set for a probation revocation hearing where the state's going to argue to revoke your probation, have you serve your underlying. So make sure, and we'll take a look and see if that paperwork's been filed for your attorney, Mr. Denu, okay?
Yes, sir.
The second matter is a first appearance. You received a warrant. I can read that warrant to you word for word, or I can just read you the short version, just the specific charges. Which would you like me to do?
The short version.
Okay. Charged with 2 counts. No, sorry. Charged with 3 counts. Count 1's unlawful distribution of methamphetamine within 1,000 feet of a school. It's a drug severity level 3 felony, and that felony holds with it jail sentences at the high end of 83, or prison sentences, high end 83 months in prison, low end 46 months in prison. You could be fined up to $300,000. So there is no possibility of a parole in that one. If you're convicted. Count 2 is possession of marijuana. It's a Class B non-person misdemeanor, up to 6 months in jail and $1,000 fine. And count 3 is also a Class B non-person misdemeanor, possession of drug paraphernalia, up to 6 months and $1,000 fine. Do you understand the counts against you?
Yes, sir.
You're being held on a $50,000 bond, but there's a hold that I just read you. And you have a right to an attorney. It sounds like you already filled out paperwork for court-appointed attorney. I'll take a look at that. It's going to be set for a status hearing. Miss Basco, anything else for the state?
Nothing from the state, Your Honor.
Mr. Danu, that's all I have for you today.
Okay.
Okay. You have any questions that I can answer?
Yeah, the unlawful distribution of a methamphetamine within 1,000 feet of it. I thought I was like at least 1,000 feet away from the school zone.
You don't want to go into that. Today's just not the day. Make sure you speak with your attorney.
I just love that reaction. It was so bad. And Judge Bone is charming. He just goes, yeah, you don't want to go into that. Oh, I enjoyed it.
Yes, sir.
Before you go too far into that in a hearing.
Okay.
All right, we'll get that hearing set for you and get your attorney so you can discuss that with him, okay?
Yes, sir.
Have a good day.
You too now.
Ms. Basco, anything else?
No, Your Honor.
Ms. Hecker, anything?
No, Your Honor.
All right, thank you, you guys.
Good morning, Ms. Bauer.
Good morning, Your Honor. I will be filing an appearance in this matter on behalf of Randy Bailey.
Oh, we've got Meg in the house. Life is good. This is Zach's fault over at LawNerdsUnite, of course.
All right, I wasn't aware of that, but I don't have any objection to it, but it does, we're already in a confused posture here today. Ms. Bailey and Mr. Millerans, would you join us, please?
Yes, Your Honor, we're present.
All right, Mr. Millerans there as well?
Yes, Your Honor.
Oh, boy. Mr. Millerans? Would you get up and put on a shirt?
Yeah. Yes, Your Honor. I'm actually trying to find a shirt right now as we speak, Your Honor. Sorry about that.
This is a trial.
I'm looking for a shirt right now. It didn't occur to him until he was on the Zoom. Okay.
Boy, I can tell you have great respect for the process. All right. The title of this case is Golden Pond Estates versus Travis Millerans and Randy Bailey. They wish to terminate their tenancy primarily because of the misconduct of Travis.
Oh, yes. I remember these people. I did a video on this. I believe I put on Golden Pond on the thumbnail because I'm just all kinds of creative like that.
Travis Millerans, who shows up for court without a shirt. Mr. Steve Cromendike is here on behalf of Golden Pond Estates. We've been tussling with this case since early December. Randy Bailey is present, and Meg Bauer is here from Legal Aid. Theoretically, this matter was set for a trial today on a termination of tenancy. Mr. Millerans and Ms. Bailey wanted a jury trial, and they don't have the wherewithal to conduct a jury trial. They didn't file the information in a timely manner. I didn't set the matter for a jury trial.
Wait, Judge, I'm
I
sorry.
had
Did they not file in a timely manner?
I can't remember. Maybe I'll take a look. Maybe they did. So you're contending there's a jury demand in here?
Yes, my understanding is that they filed a jury demand within the 5 days of the first hearing and paid the jury demand fee or had it waived.
I'm not sure that's accurate, but all right, let's assume for the sake of argument it is. I set this for today. All their witness and exhibit lists were due by January the 9th, which they filed on January 28th.
I don't believe the plaintiff filed a witness or exhibit list in this matter. He
They
didn't
didn't either.
exhibit.
So
Okay, so going shirtless was merely a demonstrative exhibit for the purpose of this hearing. I like it. I like it a lot.
plus, plaintiff filed a motion for summary disposition that the defendant has not had an opportunity to answer, and they amended the complaint that the defendant has not had an opportunity to answer. So if I understand correctly, Ms. Bauer, you'll be representing only Randy Bailey?
Randy Bailey is the listed client in our system. If the court would prefer that I make my appearance on behalf of both defendants, I can do that. And I am primarily motivated to be involved in this case based on the procedural confusion.
Well, one problem is Randy Bailey and Travis Millerans they have conflicting interests. The primary reason they want to evict Ms. Bailey is because of the conduct of Mr. Millerans.
You have articulated my apprehension about appearing on behalf of both defendants.
All right, why don't you go ahead and place your appearance on the record as who you're appearing for.
Thank you, Your Honor. Attorney Meg Bauer, P84816, appearing on behalf of Randy Bailey.
All right.
Your Honor,
Yes.
if I may, Meg and I talked for quite a bit yesterday afternoon, Meg, about a potential conditional dismissal here and what terms of that would look like. I have not been able to follow up with you until now about it. You said you were going to talk to your client, which I suppose is just Randy at that point, at this point. But in any event, has there been any progress on that?
Well, I'm glad that Meg is here. These people could use some help. They claimed that they had legal knowledge, which they don't, and that you guys can discuss this matter in a rational.
Which they don't. Oh my God, I haven't seen this. This is fantastic.
Manner. And nobody wanted to be here today. I appreciate, Mr. Kromendijk, you were going to have to drive down here from Holland, and everybody would have to be here. So on short notice, I turned this into a Zoom hearing. Ms. Bauer, do you think there'd be any merit to you either discussing it further with Mr. Kromendijk or with Ms. Bailey in a breakout room?
I did speak extensively with the tenants last night, and I thought that Attorney Kromendijk also needed to speak with his client. So I have a little bit of an understanding of the range of possible settlements based on my conversations. I am hopeful that something is possible.
I've talked to my client, and I believe he's on board.
All right. How about if I put Miss Bailey, I'll put you in the waiting room.
Yeah, get a room, like a breakout room, and discuss this. Don't try to hammer out the details on a live Zoom.
Don't go away. Meanwhile, Mr. Millerans can get pants and a shirt. And I'll put the two of you in a breakout room and see if you can get the details of the conditional dismissal. And maybe we can have some good result here today.
And Judge, I made it clear to Ms. Bailey that I was going to articulate this to you, but my presence here is primarily in service to the court. Obviously, I have an ethical obligation and legal duty, but.
Well, I've already said I appreciate your being here, and you all.
Oh, when Meg came on the scene, she was full of so much idealistic stupidity. It was absolutely intolerable. It really was. She's still got a fair amount of it, but she's growing up a little bit. The world has actually caught up to her, and she's getting semi-rational.
Very often help resolve difficult cases, and I do appreciate that. All right, I'm going to put both of you in a breakout room. I'm going to sit here and think deep thoughts for a while, or maybe not so deep thoughts. All right, I'll give you both the first line of the day. You're breaking my heart. You're shaking my confidence daily.
Oh my God. Judge Middleton is low-key on fire today. But it's so mellow. It's hard to, like, it sneaks up on you.
All right, you guys think about that.
I know it. I just can't think of the next line now.
Sing it. That'll come to you. I didn't give you the first word. The first word is the title. You're breaking my heart. You're shaking my confidence daily. I'm down on my knees. I'm begging
you please
to come
come home.
All right, you guys go in the breakout room, and I'll think about that.
I'll practice so I can get my Oscar next time.
All right.
Because I don't even know what it.
I'll leave it to you guys.
Well, the album is about 55 years old. It's Mr. Kromendijk, but you might know it. All right. Hopefully they're going to Meg just gave me, or Elaine just gave me the jury demand. I was looking for it in the file. There it is. Was filed on December 5th. for Travis Millerans. And they paid the $50 fee. Suspend the record for a minute. We are still on the live feed. World's most boringest live feed. All right, we are back on the record and back on the live feed in a matter of Golden Pond Estates versus Travis Millerans and all other occupants, which include Randy Bailey. Miss Bailey and Mr. Millerans are here. I assume you put a shirt on since we last saw him. Meg Bauer and Steve Kromendijk have been discussing this matter at some length in a breakout room. And Ms. Bauer, I'll defer to you. What's our current status?
Thank you, Your Honor. Attorney Kromendijk and I have had extensive conversation about the range of settlement terms. And although we're close, we've got a few details to massage out still. So for that reason, we'd like to ask the court to schedule
Just bang it out. That's faster.
us to keep us on track, that perhaps we have the court schedule a pretrial, perhaps a deadline for witnesses and exhibits in a couple of weeks. And we were discussing that ideally the week of February 16th, but obviously depending on the court schedule, with the hope that we'll have a settlement that we can have executed and entered at that hearing, but understanding that that's a turning point to keep us on track.
All right, the clerk did bring in the jury demand. It was in the file. I couldn't find it. It was filed within 5 days of the original hearing on December 5th, and the defendant did pay the $50 jury demand fee. So theoretically, this case would be set for jury trial. There are a couple concerns. I don't think there's currently any valid lease in effect. Do you agree with that, Mr. Kromendijk?
I do.
We've been tussling with this, as I said, since December. Will be December, January, and February. There is no escrow order in place. Is a plaintiff requesting one?
We're not, and frankly, there hasn't been an issue with payment of rent.
And Ms. Bailey, we've discussed the portal being unlocked.
All right.
Thank you.
All right. Let's look at February 16th.
And
That might be President's Day.
and my thoughts were that we don't bog your schedule down with a day blocked out for a trial at this point. Because if it's not necessary, we keep the date open for the court.
February 16th is a holiday. I normally try to be gone during that holiday, but I'm not.
I think.
Let's look at February 13th.
I think
13th, I'm going to be out of town.
All right.
Steve, are you okay with the 20th? I know that's typically the landlord tenant days are Mondays and Fridays.
20th would work.
I have an important appointment at Sunset Key, which used to be called Beer Can Island, on February the 20th.
My apologies, Judge. I wouldn't want to interfere with that.
I've got to go buggy unless I get out of here again. What is this? That takes us all the way, I apologize, to February 27th. Friday,
27th
February
would work
20th.
for me.
All right. At 11 o'clock. It's going to be problematic because I'm missing so many Mondays and Fridays in February. The days are going to be kind of dense, but I think I may be able to put some things in the afternoon of that day. So we'll block out 1 hour on Friday, February 27th
Well, the defendants will be dense anyway.
at 11 to 12 for status conference. If the matter is resolved before that time, you certainly can file a conditional order of dismissal at any time. Miss Bailey, Miss Bauer has filed a verbal appearance, and she'll file a written appearance on your behalf, and you've been discussing things at length. Mr. Millerans, my advice to you is that you continue to keep things on a low profile. There are a number of things that you are alleged to have done, which is why they want to terminate your tenancy.
Keep things on a low profile. He showed up to court with no shirt on today. What the hell are you talking about? How about start operating with a lower profile?
So
Your
my
Honor.
advice,
Don't
but I don't, we haven't got to that issue. They're accusations. So just don't bring up any more accusations. I don't want any more disturbance or discord out there.
Put on a shirt and shut your hole. There you go. Instructions over.
That'll just make their case easier. All right. Parties did work at resolution, weren't unable to get there.
Yeah, that's a question.
I'm on to speak.
Yes.
It's actually for Mr. Commondike. Because I was locked out, of the portal, can the $50 late fee that was put there for January's rent be removed? Because Casey did ask
We
for
can
the rent.
discuss that later. Right now, you can't pay your rent. In a termination of tenancy case, they can't accept your rent.
But
So
they're
they can't
asking-
say,
We're
"We're
not gonna-
accept your rent," then give you a late fee. So you can discuss that with Ms. Bauer.
Yeah.
But certainly keep stockpiling the money if there's an issue regarding rent.
Judge, we're not going to raise a Park Forest waiver argument at this point, but we'd much prefer to have the rent paid.
All right, then you guys can discuss that. Defendant will allow rent to be paid. It's interesting. It makes sense. What happens is people don't pay the rent and they don't set the money aside. They spend it on car insurance or groceries or lottery tickets or whatever. And then when it comes time to pay the rent,
Math.
the money's gone. So there is certainly logic in continuing to pay the rent. We don't have an escrow order. And that way the rent will not be an issue. So I guess I can accept that. All right, this matter's continued all the way till Friday, February 27th, which is about a month from now, at 11 o'clock. If the matter is resolved, that's fine. If it isn't resolved, we'll set a jury trial date at that time. All right, we will have a finalization of any witness and exhibit list by that time. Mr. Kromendijk, any further?
Nothing.
All right, I'll see you guys in February or sooner if you do work out a resolution.
Ms. Bailey, I will
All
give
right,
you.
Miss Bailey. My advice
Your
is you
Honor.
stay in contact with your lawyer.
Yes, thank you, Your Honor. Thank you, Meg, and thank you, Mr. Commondike.
All right, Mr. Millerant, you as well. Thank you both.
Yeah.
Thank you,
Thank
Judge,
you.
for the time. Steve?
All right, well, we inched a little closer to the finish line. I'm hopeful they can come up with a solution. We'll stop our live feed. We'll be back at 10 for a sentence.
This is People versus Mark Jerome Kavanaugh. That is you, Your Honor?
It is, Your Honor.
And for the second time in as many opportunities as this court has had to work with.
This is just awkward as hell. I mean, I guess it's a traffic ticket. I haven't watched it, but it's a judge who gets a traffic ticket. I don't know what happens in the hearing, but the magistrate does not want to deal with this. He probably knows the judge. There's no way to win here. He doesn't want to step on the judge's toes to just generally because he's a colleague. And he doesn't want to appear to be too nice to him because he's a colleague. This is just not fun for the magistrate at all. But here we are.
Officer Hadrinos, the court is compelled to place information on the record related to a familiarity. Officer Hadrinos, just so that you're aware, this court, outside of court, has been I guess we could say a colleague and a associate, but not a close friend of Judge Kavanaugh for plus or minus 20 years. Is that about the same period of time you recall, Judge?
Yeah, I'm one of your groupies when you used to play in your band. I come in being a music person myself, so we did that. Okay. Yes.
All right.
But I would say, I mean, we're friends in terms of I wouldn't meet you up or anything, but okay. we don't interact socially.
So, Officer Hadrinos, first turning to you, are you comfortable with this court proceeding as a neutral in this matter, notwithstanding that it's familiar with Judge Kavanaugh?
Fine, Your Honor.
Very well. And same question to you, Judge Kavanaugh. You are comfortable with this court proceeding as a neutral in this matter. You don't believe this court will be any more or less fair to you based upon its familiarity with you?
Not at all. And I didn't really even know that you were going to be here until I looked at the notice again today. So I'm not even prepared to try to convince you or make you soft in any way for my position.
Very well.
Absolutely accept that.
Thank you. I appreciate that. So I believe the court already read the citation number into the record. And Judge, you were present a little bit ago when the court explained to a group the nature of the informal hearing process.
Yes.
So
here's the problem too. I think everyone's handling this well. They're being kind of light about it and rolling with it. But let's say he says, okay, I'm going to recuse myself. He'll know the next one too. He's going to know anybody he's in front of. There aren't that many. All these judges know each other.
Understand you must select from one of three options.
That's a fuzzy one.
Let me proceed. I got a procedure here to try to redress that. So
I remember the three. The three.
Well, let the court read the citation.
Go ahead.
It suggests that on December the 29th at 10:01 in the afternoon, you were operating at.
I am a sucker for fishnets and a slutty dress. I just don't know if Judge Kavanaugh can pull it off.
2019 Audi, white in color, on 14 Mile Road, near Delamere, City Royal Oak. And at that place in time, you were cited for driving too fast for conditions. The officer's remark indicates westbound 14 Mile, made right turn onto Delamere, slid through intersection, struck another vehicle. So that's the sum and substance. Your three options, if I can remind you, are you can simply admit responsibility. The court attaches a fine between 0 and the max, and that closes the case. You can admit responsibility with an explanation that you believe mitigates those circumstances. Or if you don't believe that you are civilly liable under the circumstances for the traffic citation, you can deny responsibility. We'll swear the parties and conduct your hearing. What do you wish the court to do?
Well, that's a good question. I think under the citation, as I understand it, I'm really not all that familiar with the traffic things, I have to admit. But I think under the case law and under my view of the circumstances, I'd have to say I'm not responsible.
Very well. Would Both you gentlemen, please raise your right hands. You solemnly swear the testimony you shall give before this court shall be the truth.
Yes.
Yes, Your Honor.
Thank you very much. The officer's got the burden, obviously, Judge, and then it's your turn. Officer Hadrinos.
Your Honor, I was dispatched to this accident on the 29th of December, approximately 1:10 in the afternoon. Upon arrival, I spoke with both drivers. Mr. Kavanaugh admitted that he slid on the ice. He was westbound 14 mile, making a right-hand turn onto Delamere, and he stated that there was ice and he slid into the other car. Therefore, I wrote the citation for too fast for conditions because the roads were very snowy and icy. Therefore, he should have been going at a slow.
All right. From what I'm seeing so far, I think that this is pretty damn impressive, honestly. We've got a too fast for conditions, which is kind of a rough ticket. I understand why, because you can be driving pretty carefully and still be driving too fast for conditions. I don't know what happens. I don't care what happens. But what I'm seeing here makes me proud of the profession. Everyone in good faith is participating in this. The judge, who is the defendant here, is not pulling rank and acting like he's above it. He's simply saying, I want to dispute this for whatever reasons. We'll find out. But he's not saying, I'm above the law. I'm a judge. You can't write me a ticket. He is simply saying, based upon the facts, I would like to dispute this. The cop, who does not want to write the judge a ticket, but does because he feels like he should. The magistrate does not want to preside over this, but does it because he thinks he should. This is awkward, but it's not of anybody's making, and everyone's doing the right thing. It's actually pretty damn cool. You would be hard-pressed to find this in any other country on the planet. I'm being serious.
Lower rate so that he could make the right turn without sliding into another vehicle.
Okay. Is there anything else you want the court to know other than your right to rebuttal should you choose to use it?
No, Your Honor.
Okay. It is your turn.
All right.
Would you like the court?
Best. All righty. I was headed down 14 and I was, well, first of all, I've been driving for 56 years. I've never had a ticket. I've never had a citation or an accident or anything that I can recall. But seriously, I don't believe I ever have. And I know about.
My God, he looks damn good if he's been driving for 56 years. Seriously, I'm impressed. Good on you, Judge Kavanaugh.
Driving under those conditions. I've had 56 years or 72 years of winter, Michigan winters, and I know that that was a day that they referred to as a cyclone winter day. I remember reading that in the paper. It was particularly bad, as the officer mentions, and it was icy and it was snowing, and I know about keeping a clear distance, which is what I was doing on 14. I was coming from 12 and a half in Crooks, where I live, and I was going up to that mall where Home Depot is. And, you know, some people were going fast, and, yeah, I was getting a little bit nervous, but all along from Crooks to Delamere, you know, I had to stop and go, lights, whatever, and I kept enough of a distance so that I never found myself in an awkward position. And I mean, as I say, I've been driving Michigan winters for all these years, and I think I know how to drive them.
Okay, I get the dispute here. I get it. This guy was not driving like a maniac. He does not drive like a maniac. But this particular provision, and he's also not a traffic judge, so he's not dealing with this stuff all day. But this particular provision in Michigan is if your car slides, you're presumed to be driving too fast. It's almost like a res ipsa. Did that clarify it for y'all?
And so at any rate.
But that's why we are where we are.
I was a little bit concerned about 14 Mile because there were people that were going a little bit faster and I was comfortable with. And I wanted to try to restrict my exposure to that by cutting down Delamere, which is a lesser traveled road, and then taking the road parallel to Meyer and then getting back on Coolidge. And I was probably, I don't think I'd be surprised if I was doing 30 at any particular time on 14 Mile Road because of the conditions. I mean, it was very bad, and I was very conscious of that, as I have been all these years. And I decided to make the turn on Delamere. I put on my light. There were no cars around or anything like that. And naturally, I had to slow down to make that turn. And I was already, I felt, going under the speed limit by far on 14 Mile Road. Anything less, I would have been parked, I think, just about. But at any rate, when I started to make the turn, I hit some black ice. And I've had a lot of cases involving black ice, and I'm not trying to, appeal to authority or whatever. And I'm familiar with the term black ice, and I know that's exactly what it was. I knew the roads were not good or whatever. And I slowed down to make this turn, and I felt the car starting to go, and I hit my brakes, and they locked or whatever it was. And I slowly slid into this guy, and I was freaking out. I didn't know what was happening. And I binged him. And I did everything I could do to control my vehicle, both on 14 Mile and as I was making the right-hand turn. And as I say, you naturally have to slow down for a turn, and especially under those conditions. So I felt that I was using, for lack of a better word, due diligence or whatever. But anyway, the other gentleman wanted to make a report. And so I looked at his car, and I took some pictures, and I actually had a difficult time finding anything on the car. It looked to be that he was scraped or whatever, if there was even that. I could tell that he had been hit. But as far as I could tell, there was no real body damage or anything like that. So that, to me, is further evidence that I was not going beyond a speed that would be safe under the circumstances. The fact that I was turning, the fact that I barely hit this guy or the gentleman or whatever you want to say. And I think I just feel like, based on my habits of driving all these years, based on case law and unsuspected conditions, this was completely unsuspected to me. And as I say, I was doing everything I could to drive carefully because, of the weather. It was not a good day. And it surprised me, and it sort of shook me up too, to even have to go through something like this with this gentleman. And I'm sure he didn't feel good. Now, I've not heard anything from him. I've not heard anything from his insurance. And I do not think that there was any damage. And I know that's not the pivotal point, but that, as I say, is an indication of the fact that I feel that I kept a clear distance as I was going down 14 Mile Road. But for this completely unexpected black ice, my car would have turned, as I've done many times, coming off 14 Mile onto Delamere, and knowing how to do it. And of course, cars are there waiting to come off of Delamere onto 14, and I do try to pay extra caution. So I really think that I was doing the best that I could. And as far as I'm concerned, I was in total control of my car. And I was keeping within a perfectly reasonable speed limit. And there's really nothing I could do with this black ice. And that's how I feel.
Thank you. Officer Hadrino's rebuttal testimony.
Your Honor, with all due respect, the number of years that the judge has been driving has no bearing on this. The fact that he did have an accident is factual, that he was not going at appropriate speed for the conditions of the roadway. If he was in fact going the appropriate speed for the roadway, would have never met, because there would have never been an accident. The fact or non-fact, whether or not there was significant damage to the other vehicle, is also no bearing on this case whatsoever. There was contact between the two vehicles. He was clearly driving too fast for the conditions, or there would never been any contact between the vehicles.
Thank you. And just
definition of that citation.
Just for the sake of clarification, this wasn't written as specifically indicated, fail to stop a sure clear distance ahead, but written in essence under the basic speed law, driving too fast for conditions under MCL 257.627 or its local comparative, correct?
Correct.
All right. The court has heard the testimony of both parties in People of the City of Royal Oak versus Mark Jerome Kavanaugh. The court is not required to make specific and itemized findings of fact. However, the court would note first that it believes both parties are proceeding in good faith based upon their best perceptions and recollections of the incident. The court also notes that the burden of proof in a civil matter under these circumstances is a preponderance of the evidence. Looking at 257.627, it indicates an individual operating a vehicle on a highway shall operate that vehicle at a careful and prudent speed not greater than nor less than is reasonable and proper, having due regard for the traffic, surface, and width of the highway, and of any other condition existing at the time. Doesn't necessarily suggest any other condition except for hidden conditions. There don't appear to be any necessary exceptions to that. And it indicates shall not operate on a vehicle at a speed greater than that, which will permit a stop within a sure clear distance ahead. So it is the basic speed law, both as to speed, conditions, road conditions, width of highway, etc. There was a specific use of verbiage which indicated in control of the vehicle at all times, but the court would not and would never believe that it was the intention of Judge Kavanaugh to, while in control of the vehicle, strike another vehicle. The court even might hearken back to Professor Callahan back in 1985, who taught us the principle of res ipsa loquitur, meaning the thing speaks for itself. So while it is a closer shave than some, the court is finding you responsible under these circumstances. Please stand by. All right. The fine in this matter is $150, and there is an accident fee. So the total is $195. That is payable through the pay portal on the 44th District Court website, or Judge, you can walk a cash check or charge into this court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. It's due within 7 days. And if you take exception to the court's ruling and you wish to make an appeal, you have every right to do so by posting a cash bond of $195 within 7. The matter gets placed upon the formal hearing docket. And
this guy apparently was on the appellate court. He would actually know how to do the appeal right.
At that point, the city is represented by City Attorney Ryan Kaluzny. So $195 as a fine or a bond within 7. That completes your hearing. Please be careful out there. Good seeing you. Thank you.
And Your Honor, I believe that the...
All right. I stand by it. I stand by it. That is a testament to our system. That was some straight-laced stuff there. The cop didn't want to write this ticket, but he had to as a matter of law. The magistrate didn't want to find him responsible, but he had to as a matter of law. The judge was respectful of the process. He lost, but I understand why he disputed it, because he was driving very safely, just not safely enough. And that's the way it is. Also, I need to correct something. I blamed the wrong person for the first clip. It was Jalapeno, not Evan. Evan's working on something else. I want to distribute the blame properly. This one right here got sent to me by Beck. It's pretty interesting. It's SovCit stuff.
The individual remaining in the courtroom would like to introduce himself to the court.
Hello, my name is Colton James, family name Waslin. I'm here today by special appearance solely to address discovery and clarify matters from the previous hearing. I am not submitting to the court's jurisdiction for any other purpose and preserving all objections related to jurisdiction. At my last appearance, I was under the impression that there would be no plea entered and the papers would reflect that, as well as me maintaining my innocence, including my constitutional right to assert my innocence. I want to reaffirm that I am maintaining my innocence.
If you want to make a statement on the record here, because we are on the record in court, you have to speak into the microphone so that it can capture your words.
Is this on the calendar? I guess I'm just confused as to what.
It is. I want to get to that.
Where's the microphone?
It's sitting at council table right there.
Okay. Would you want me to sit or?
Yes.
Okay.
Let's start again. What is your name, sir?
My name's Colton James, family name of Waslin.
Waslin. Colton Waslin, cause number 5A0561562 and cause number 5A0561563. Mr. Waslin, I see that we're here for a pretrial hearing. Let me hear from the city first.
I do not believe that Mr. Waslin has gotten an attorney yet, and don't know if he wants one. I believe he mentioned at the last hearing that he wished to proceed pro se, but that's not really something in the control of the city.
Okay. So first things first, Mr. Waslin, you need to be represented by legal counsel, or you need to represent yourself. Would you like to apply for a public defender, or would you like to hire an attorney of your own?
I wish to be here at present as myself.
I can see that you're here at present as yourself. What I'm asking you is whether you would like to be appointed a public defender, or whether you would like to hire an attorney of your own.
I wish to do neither.
Well, so, Mr. Waslin, you're not allowed to appear without counsel unless you are asking the court to approve that you be allowed to represent yourself in pro se.
I thought my right was the ability to represent myself.
No, it is not. You have the right to legal counsel at any criminal proceeding. You can be provided a public defender free of charge if you qualify financially, or you have the right, of course, to hire an attorney of your own. If you qualify in terms of what the legal requirements are to represent yourself as your own legal counsel, you may do that. I don't recommend it, but we can go through that procedure if that is what you are requesting.
Would I just be able to get a continuance then at that point? Because I need to brush up on a few things so that I may accurately defend myself.
I'd hear from the city. If Mr. Waslin is making a motion to continue, he is not currently represented.
Your Honor, I don't have an objection to the continuance. I don't think we need to do a colloquy today. It doesn't sound like he's quite there where he's necessarily waiving. He's still making that decision. City doesn't have an objection. We would need a speedy trial waiver. I believe Speedy's running well, actually, let me check if it's running from today or if it's running from Sorry.
So I see.
Yes, he needs to brush up on the law. And since he doesn't know anything, I suggest a 7-year continuance for him to attend college and law school. Thank you, Judge.
Two cause numbers, according to Jabs, pleas of not guilty were entered on the 28th.
Also, I need to shout out Court Watch. This is their video. I put a link to the original video and a link to the channel in the description.
Of August.
Which was a misrepresentation of what my intentions were, which is what I also wanted to talk with the court about.
Your Honor, the docket makes it very clear the defendant stated he is innocent of the above charges. That's what was discussed last time we were here. He seems to be rejecting the terms used in this court, but he made an innocent plea on 8/25, and it does look like we would need a speedy trial waiver if there was going to be a continuance today.
I do see that in looking at the court's record, Mr. Wasland, it states that you stated that you were innocent of the charges, which is not the language that we customarily use, but if you are not pleading guilty, you are going to be pleading not guilty. There is no third option. That said, it was noted as entered back in August, not guilty pleas to both charges, which preserve your constitutional rights to trial and everything else. We will hear your request for a continuance today. If that's what you want, I'm prepared to grant it. Counsel for the city has reminded us that the speedy trial requirement, that is to say the time requirement for you to be brought to trial constitutionally under the state of Washington's laws, requires you to waive that speedy trial if you are asking for more time, because a continuance would take you out beyond that.
Okay, just out of clarification, so the Sixth Amendment does not give me the right to represent myself?
I am not your attorney, Mr. Wasland, and I am not attempting to give you legal advice.
But you are saying that I have to ask to represent myself when I believe that the Sixth Amendment right is the ability to represent myself as like a constitutional right. So I'm asking the court on why that it's not really being allowed in this situation.
I am not engaging in a colloquy with you about whether or not you're qualified to represent yourself. I think that the court will be willing to do that if you indicate, in fact, that you do want to do that. I had heard that you were asking for a continuance in order to better prepare, which frankly is a good idea.
That continuance was only due to the fact of
Mr. Wasland has gotten an attorney yet, and don't know if he wants one. I believe he mentioned at the last hearing that he wished to proceed pro se, but that's not really something in the control of the city.
Okay. So first things first, Mr. Wasland, you need to be represented by legal counsel, or you need to represent yourself. Would you like to apply for a public defender, or would you like to hire an attorney of your own?
I wish to be here at present as myself.
I can see that you're here at present as yourself. What I'm asking you is whether you would like to be appointed a public. Pleas of not guilty were entered on the 28th of August.
Which was a misrepresentation of what my intentions were, which is what I also wanted to talk with the court about.
Your Honor, the docket makes it very clear the defendant stated he is innocent of the above charges.
Constitutional right. So I'm asking the court on why that it's not really being allowed in this situation.
I am not engaging in a colloquy with you about whether or not you're qualified to represent yourself. I think that the court will be willing to do that if you indicate, in fact, that you do want to do that. I had heard that you were asking for a continuance in order to better prepare, which frankly is a good idea.
The continuance was only due to the fact of you saying that I wasn't able to represent myself or act, for myself, defending myself. If I am able to, then I would like to continue and we can go. But if not, then a continuance would be in order so that I can revisit a few things.
So to take the first issue first, Mr. Wasland, you are not constitutionally guaranteed the right to represent yourself in court. You are constitutionally guaranteed the right to have an attorney represent you. If you wish to represent yourself in court, the court may engage in what is known as a colloquy with you at a later time, that is to say, not today, in order to see if you are qualified to competently represent yourself. That's something that can take place at a later date. The court will hear your motion to be qualified as a pro se defendant. I also heard that you are asking the court to continue these cases so that you can have time, presumably, to prepare for that colloquy, if that's what you want. I'm prepared to grant it. I will tell you, though, that I cannot grant it if you do not wish to waive your speedy trial right, because your trial is currently set. Pardon me, it's not set, but we have speedy running when?
From the 28th of August.
That would take us sometime into next month.
Mm-hmm.
How much time are you asking for as a continuance, Mr. Wasland?
Well, honestly, I only came here by special appearance to assert innocence and request discovery, but given the matters that...
Your not guilty pleas have already been entered at your last court appearance.
Which I didn't want to plea or contract with the state or city of Bellingham, which was the issue at hand. I just wanted to maintain my constitutional right of innocence is...
Your constitutional right to a trial and the presumption...
City of Bellingham, where is this? Where is this court appearance? It looks like it was... I don't know, because it's reversed on there, but it looks like it was January 1st, 25. It's a little over a year ago.
...of your innocence, as well as your right to an attorney, and all of the other rights that were discussed are maintained.
I would like to maintain all rights and not just the ones discussed.
I would like to maintain your rights as well, Mr. Wasland. I'm asking you as to your speedy trial right, which is a rule of court here in the state of Washington.
Okay.
If you're asking for a continuance, you need to tell me whether you want to go to trial before November 28th or wish you'd rather to continue until after that date.
We can go before if you want.
I don't have any position in the matter, Mr. Wasland. You're appearing before this court.
I'm fine with that.
And
You're fine with what?
With going before.
Perhaps what might make sense is if we just set it over without a speedy waiver, do a very short set until the presiding judge is back and can go through the colloquy, perhaps a week or two.
Certainly, I'll say that, Mr. Waslin, we can continue your matter inside of the time remaining for the speedy trial requirement.
Okay.
But it will be a very short amount of time to prepare for trial if that is what you wish to do without waiving speedy.
That is fine, as long as I am able to pick up my discovery today at the end of court. That'd be totally fine with me, because they have not done their obligation of submitting it to me by CR R 4.7.
So, Mr. Waslin, as I understand it, you do not have counsel appointed or having made a notice of appearance in this case.
I'm a notice of a special appearance, yes.
And
Your Honor, the city will follow the rules of discovery for criminal procedure. Soon as we get a request for discovery, we will comply with it within the timeframes that we're required to.
Thank you, counsel.
Your Honor, what I understand the preference, but CR 4.7 allows I'm preserving my rights while requesting discovery, and the continuance I'm obligated to have that, not necessarily by written. So this would be my formal request.
Yeah, it doesn't matter. You just got regeared, son.
The city has indicated that they will follow the court rules regarding discovery, Mr. Waslin.
And can I pick it up today?
No.
Okay, tomorrow? Monday?
Mr. Waslin, you'll address the court while you're sitting before the court.
Okay.
I'm trying to recall the rule of court that requires presence in person or virtual or via counsel. And I believe
3.4.
3.4.
It's 3.4, yes.
Just as clarification, this is the omnibus hearing, right?
No, it is not.
It's a pretrial?
That's correct.
Okay.
Mr. Waslin, we have a court appearance that we are setting in your two cases.
Judge, I'm going to be filing a motion to tase the big dummy and Stanter. That's okay with you.
As I said, you are to appear timely. You are to not violate the criminal law of the state of Washington. You are to update any address changes with the court and with Department of Licensing. You are to only use your true legal name and date of birth to identify yourself to the court, and you are not to drive without a valid license or proof of liability insurance. I have noted on this order that the defendant has requested a continuance. He has noted that he does not wish to waive speedy trial, and he has requested to represent himself in pro se. Arraignment having already been accomplished here, not guilty pleas entered and probable cause found. I don't think that there's anything further.
Just promise to. He just needs to sign a promise to appear.
Okay. Mr. Waslin, the promise to appear is before you. When you sign it, we will have a copy made for you so that you can take it with you.
Okay. What about the discovery?
Oh, we haven't even gotten to Mirandaization yet.
The parties to this litigation are bound by the Washington Rules of Court, which govern production of discovery documents. Counsel for the city has indicated that they will follow those rules, and I have no doubt that they will.
Okay.
Your attorney, or you, if you represent yourself after you have been allowed by the court to represent yourself, can make a request for that discovery, and it will be responded to.
So I do understand the preference of making the request. However, it is up to them to to be, it said the CR 4.7 says the prosecuting attorney shall disclose to the defendant.
Mr. Waslin, you're not an attorney.
No,
You
but I'm
don't
just
represent
asking you,
yourself
like, I'm
right
asking
now
you to
today.
have them.
You don't
you know.
represent yourself. You have not been allowed to represent yourself yet. You have the right to have an attorney represent you, and one can be appointed to you if you want, and you qualify. Now, if you want to request that the court allow you to represent yourself as your own attorney, that is a legal procedure known as a colloquy that you can engage in. I heard you ask for a continuance so that you could prepare for that, and I granted it. I cannot give you legal advice, sir. I can only tell you when your next court date is and what the order of the court is.
I'm not asking for any legal advice. I'm asking for them to at least, be obligated to give it to me without the referral request or the written request.
Your Honor, it requires a written request. 4.7 requires a written request. If we get one, which can be as simple as emailing, you can email me, which is me, and I will make sure that request, that discovery gets to you.
So I have to ask you for your obligated
Mr. Waslin,
obligation?
Address the court when you're sitting before the court.
So I have to ask them, outside of the court for their obligated duty to fulfillment.
All right. Then do we have Mr. Mula here? Excellent. This is case number 25M1510. I understand, Mr. Sullivan, that your office might have a conflict with this case?
Yes, Judge, and I believe it was filed with the court.
Okay. So let me unmute Mr. Mula. So good afternoon, Mr. Mula. This is Mr. Sullivan. He's here with the Office of the Public Defender.
Yes.
They have a conflict with your case, so if you remain in custody, I'm going to appoint a lawyer to represent you.
I represent myself, ma'am.
Okay.
It's a right. So
Sure.
I represent myself. Yeah.
Thank you. I don't need you to advise me of the law, sir. But if you'd like to exercise your Sixth Amendment right to represent yourself, you may. Let me hear the people's bond argument, and then if you'd like to make an argument, you may. I'm going to mute you while they do that. Thank you. Ms. Mayfield, what is your argument regarding bond?
Honor, I don't think I have an argument under 164113.
So I'm not sure if you do you know what happened yesterday?
Maybe not.
So, yesterday, Mr. Mula appeared in Division 7 and was extraordinarily disruptive, using very foul and offensive language, very obstructionist behavior in the courtroom, failing to adhere to court orders, to appear at the lectern, essentially failing to adequately identify himself. What I'm going to do is allow you to make any argument you'd like to make, Mr. Mula, and then I'll make a ruling regarding bond.
Yes, ma'am. I was illegally detained on a bench warrant that was issued while I was in a courtroom for a non-appearance. So, yes, I got irritated. I know my rights, ma'am, and I have the right to travel in regards to the first trespass charge. So also I work with the homeless community here.
Okay.
I work with all the programs.
Okay. If you could wait just a sec, what I'm going to do is ask you questions under the statute. I'm going to ask you questions under each subsection. Don't talk about the allegations, okay? So what is your full name and date of birth?
I'm Johnny Lay, free and living man, all rights reserved.
In the event that the court were to release you on a personal recognizance bond, would you sign that bond?
Yes, ma'am.
Okay. Let's see. What are your ties to the jurisdiction?
To the jurisdiction.
To Boulder. Boulder
I've
County.
been here for 2 years, seeking sanctuary, and I've been bullied and targeted and harassed by cops and other organizations since I've been here for helping the homeless.
Okay.
I hang out with Mike Lau.
And just wait. Ms. Mayfield, you said you don't know of any record you could make under E or F.
I do not.
Okay. All right, Mr. Mula, was there anything else that you wish for me to know before I address your bond?
Nope.
All right. Okay. What the court is going to do is authorize a $1,000 co-signed personal recognizance bond, no contact with the victim, pretrial supervision.
And who is the victim?
Let me take a look.
And what are the charges? I didn't hear any charges. So.
Yep. So let me tell you, you were I think, issued a summons, but let me take a look. Yes, you were. And so when you were issued the summons, the
I don't have an address.
oh, just a sec.
I live in a car.
Somebody likely handed it to you, but let me take a look. And how about we do this? I don't interrupt you and you don't interrupt me.
Sure.
All right.
Thank you.
You're welcome. Yep, it looks like the officer tried to hand you the summons, but you refused it. So let me share with you what the charges are. You're charged with the unclassified petty offense of third-degree trespass and the Class 2 misdemeanor of obstructing a peace officer. As it relates to the address you are alleged to have trespassed.
Kevin G. Fine.
Well, do you see that, Ms. Mayfield? That it's Evan G. Fine? Oh, here. Oh, yep, it is. So when I say no contact with the victim, it's Evan G. Fine.
Okay.
Okay. You asked me what that was. So now let me tell you.
Can I ask a question when you're done, ma'am?
You may ask that question right now if you would like.
How is a public space a victim?
So you are trespassed from that area, and so what I'm saying to you is no contact with Evan G. Fine Park.
Well, the officer that I had initially interacted with said that it was only during the hours of 11 to 5.
This is 25 CR 3889. Mr. Gavin appears out of custody here for a first appearance. There is one formal charge that's been filed. And Mr. Slocum, do you have a copy of that complaint information?
This one is fantastic.
And I'm sorry, was this Mr. Gavin?
Yes.
Okay.
And so this is a copy of the complaint information. So hang on to that. It has some limited information about the charge that was filed and your case number. Mr. Gavin, are you planning on applying for the public defender's office?
No, ma'am.
Okay, you're planning on hiring a private attorney?
No, ma'am.
Okay, you're just going to represent yourself?
Yes, ma'am.
Okay.
Okay.
All right. Well, Mr. Gavin, do you have any legal training?
No.
Okay. Have you ever filed a motion for, have you ever had a motions hearing?
I'm not illiterate, Your Honor.
I'm certainly not implying you're illiterate.
I feel. So can we please approach?
Okay. No. So my concern is that you want to represent yourself, and it's not that I'm implying you're not intelligent. What I'm trying to just advise you of is that the legal system is really hard to navigate, and
I'm implying he's not intelligent, Judge. Right here. I'm fully implying that he's not intelligent in every way I possibly can.
It's very complicated.
Your Honor, I understand, but that has nothing to do with me, Your Honor.
Okay. All right. I'm going to give you an advisement here. It's called an Arguello advisement, and it's required for individuals that want to go forward pro se and represent themselves. I want you to know that you have the right to counsel. You can hire a private attorney.
It's designed for big dummies like you.
Apply for the public defender services and see if you qualify, and then one would be appointed at no cost to you. Do you understand that you have the right to be represented in this proceeding?
Your Honor, is there a bond on this?
Sir, if we can't get through an Arguello advisement, then I can't continue your case. So we're either going to get through this advisement, or I'm just going to keep setting you over until we do. So what would you like to do? Go through the advisement so that you can then represent yourself and your case can move forward?
Your Honor, is there a bond on this case?
You're out of custody, so you've posted a bond if there was one.
Is there a Social Security on this case?
I don't know what that means. A Social Security what?
My Social Security number.
Yes, your Social Security number is associated with you in this case.
Right, so it's tied to all my charges, correct?
Your Social Security number?
Yes.
If it's associated with you and you're associated with this case, then I would assume it's a part of...
So I am the beneficiary, correct? And you are the fiduciary. You are the servant of the state.
Okay. So, Mr. Gavin, you have an active warrant in another case in 21 CR 5803. There was a failure to comply warrant that was issued on September 5th. And there's a no bond hold. So you're gonna be remanded and go into custody on that case. And what we
September 5th, I was in custody.
That's when the warrant was issued.
I was in custody, ma'am.
That very well may be.
You probably were because you're a big dummy and you know, do lots of dumb things. So you probably were in custody, but I don't care. I don't care in the least. You have a warrant. You're not going anywhere. Too bad. So sad.
So the warrant was issued on September 5th, advising that you failed to comply in 21 CR 5803. Having an attorney would certainly help you understand everything that's going on. Either way, you're going to be remanded on that case. And then this case is going to...
The bailiff can't touch me. That's illegal for the bailiff to touch me. You're a servant.
Sheriff.
You're a deputy sheriff, either or. You're not allowed to touch me.
That's not how this works.
You want to bet? How much you want to bet on that proposition? Let's see how this unfolds.
How is there a warrant? How is there a warrant for someone in custody?
So I think what I'm going to do with this case, I haven't gotten through an Arguello advisement, but I tried and it doesn't seem like we're going to get there. So I'm just going to send it to Division 8. We'll set it for an arraignment.
Yeah, you got a warrant. You're not going anywhere. I'm going to let another judge handle this. I like her.
There, we'll make a note that Mr. Gavin is wanting to represent himself. And that he still needs an Arguello advisement, and Mr. Judge Bentley can work on that. And then Mr. Gavin will be remanded on 21 CR 5803 in that court.
I'm not going to be remanded for something I didn't do. I was already in custody.
No, you're going to be remanded for something you did do. We're all going to enjoy it. It's going to be beautiful. It's going to be just a nice, heartwarming moment.
It doesn't matter.
It does matter. How do I get another charge if I bound?
I
bonded.
Listen, I could explain this to you, but you're not, so I can't explain.
Your Honor, I bonded out.
On this case.
Yes, there was no other case.
I'm talking about a different case.
How do I have another case if I'm already in jail?
It's 21 CR 5803.
Oh, look who's here.
25, excuse me?
21 CR 5803.
And
that's convenient. You're going to need some bailiffs here. Apparently, someone pressed the button or whatever, because they somehow got the signal to show up.
What is this under?
This is a case.
What are the charges?
Case. So that's the case you're on probation for.
I'm on probation on all the cases because I'm already on probation, Your Honor.
Not in this new case. This is your old case that you're on probation for.
But I was already in custody.
I understand that on this case, and you bonded out on this case.
I bonded out.
And then there was a warrant issued on your...
How was there a warrant?
Because there was a failure to comply based on this new case. When you're on probation, it's a violation of your probation to get charged with new cases.
Okay, so what is this number again, please?
Mr. Gavin.
Can I get this case number?
She said it.
I'm trying to get right down this case number.
Sorry, I've given it to you multiple times. I can't help
Yeah, too late.
that you're not listening to me.
I'm just trying to put this, man.
Yeah, I'll grab that.
Damn it, every time I come up there, y'all trying to put me in here, man. I'm tired of you, Honor.
No, they're not trying to put you in there. They're succeeding in putting you in there. Enjoy the crappy food.
Too. You're just a servant here.
Don't resist, man.
I'm not resisting.
You are resisting.
Man, you trying to hit me on a pin cap, dog.
Resist. With your hands behind your back.
I have my hands behind my back. If you guys are over and you act, that's fine. Because I can slam all y'all.
Stop resisting.
I'm not resisting.
You are.
How am I resisting, Martinez?
I don't know who Martinez is, but it's not me.
Well, don't know. How am I resisting? Just bonded out. So y'all try to play the game and bond out to take people's money, right? Now,
I'm perfect. Let's do it. All right.
My things. Do I have my,
We'll grab your things.
I have my information, correct? Public servant shouldn't be able to do this. To a citizen that's solid.
Now, how are we going to?
Ah, that was beautiful. That was beautiful. I told you I had a heartwarming ending for you. That was my favorite. I wanted to end on a high note. It was beautiful. would be even more beautiful if my internet would work all the way through. It's weird. It does sometimes it doesn't. What are you gonna do? It was still awesome. Thank y'all for coming out. I appreciate it. I will see you soon.